Good afternoon, Advocate Malindi. Just switch it on and leave it on.
Good afternoon, Chief Justice and the Commissioners.
I noticed that you've been interested in what happens in society from a fairly tender age, starting with COSAS.
I have been Chief Justice.
Just share a bit of that side of your life with us.
Chief Justice, in 1976, having read the events of 16 June in 76, I became informally involved with other students, and my involvement led to my detention in September 1976. And then thereafter, we formalized our student activism in the Val. And then in 1979, we formed the committee to establish a branch of COSAS in the Val, which was formed in 1980.
And you have consistently been involved in that line of activism until when?
Chief Justice, thereafter, when I outgrew COSAS, I was part of the Val Youth Congress interim committee, which was only formed after my arrest and imprisonment. But before imprisonment, I also worked with community members to form the Val Civic Association, which affiliated to the United Democratic Front in 1983.
Yes. Very well. And from what I could gather from your questionnaire and CV, you have never really stopped being keenly interested in what happens in the broader society.
Yes, Chief Justice. Whilst we were in the United Democratic Front, some of us were then approached to join the ANC underground, which we did. And after my imprisonment, I, as one could say, formally joined the ANC on Robben Island, and again formally joined it again after the ban on the ANC and other liberation movements were lifted in 1990.
Yes. When did you begin practice?
I began practice by doing my pupillage in January of 1995 and sat for the exams in June, and I was admitted as a member of the Society of Advocates Johannesburg in July 1995.
So for how many years have you practiced as a junior, and for how many as senior counsel?
All in all, I have practiced for some 21 years as an advocate, 5 of which has been as senior counsel, which was awarded to me in October 2010.
You've acted as a judge.
Indeed.
What challenges of note have you picked up which you might wish to share with the Commission so that it's better informed about the challenges that affect the judiciary or acting judges or judges? Very briefly, if any.
Chief Justice, when I first acted in the first years of 2010, 2011 and 12, that was when the motion court was particularly stressful, when judges were receiving up to 300 files of unopposed matters, of which some 10 or sometimes more will be opposed matters. That was very stressful for a person who's acting for the first few stints. Also, being in the agent court, which I did both in the labor court and in the high court, it was challenging in the regard that one had to write judgments in the agent court immediately, and most of the time I would deliver my judgments the next day, which meant that I had to work overnight most of the time to deliver those judgments in an agent court as speedily as possible. It was the area with the most challenge. And unopposed motion courts were also a challenge because there were hundreds of them at any given time, especially in the High Court, which required a judge to be on top of those issues without the assistance of counsel. So I did find unopposed motions particularly strenuous.
Yes. JP?
Thank you very much, Chief Justice. Good afternoon, Advocate Malindi.
Good afternoon, Judge President.
Mine is just to deal with what you did when you were acting, just to portray whether you are ready to be appointed as a judge. My spreadsheet tells me you've done 19 weeks in the High Court only. Does that accord with your own records?
Accords with my own record, Chief.
Yeah.
Just keep your mic on, Advocate Malindi.
It accords with my record, Judge President.
And thank you very much. In that time, you've done 5 weeks of opposed motion as well as 4 weeks of unopposed, 1 week in the agent court.
Indeed.
Are those easy courts to deal with?
They are not easy courts at the beginning, but one soon grasp the essence of running those courts. And in my subsequent acting stints, I have found it easier and manageable, and I acquitted myself better than when I first started.
Right. And you've also acted in the labor court, am I correct?
I have also acted in the labor court.
In what work areas did you act in the labor court?
I acted in reviews,
Is that opposed reviews?
opposed reviews. I acted in the opposed motion ordinarily. I acted in the unopposed motions, and I did trials as well.
Right. In terms of you doing 5 weeks in the opposed motion, you'd have picked up judgments there, reserve judgments.
I have picked up reserve judgments, and especially on 1 or 2 occasions when I did special motions.
Okay. Yeah. Any particular issue you want to mention about the judgments you picked up there, and any difficulties in writing them? In the High Court, that is.
Chief Justice, there are matters that are not easy of quick judgment, and I remember in particular a special motion matter which involved international trade, and there were issues of guarantees and counter guarantees, which I needed to particularly study the documents, the heads of argument in it, and ultimately I delivered it after some 3 or 4 months. That is the matter of Denel, which is listed amongst my papers.
Special motion, that would have been in Johannesburg, isn't
That
it?
was in Johannesburg.
Yeah, because it's not reflected in my spreadsheet. That was an allocation out of 10 by the DJP. Is that correct?
That is so.
Thank you. Now, as an advocate, you're the second black male silk who's available this time. And want to ask you the same questions I asked Advocate Madima. Have you had occasions to be lead counsel in the SCA and in the Constitutional Court?
I have Judge President, and in the matters that I have listed that appear on page 20 of my bundle, in the first matter, Democratic Alliance versus African National Congress, I led Salim Ibrahim and Yusuf Saluji. And in the South African Informal Traders Forum and others, I led Tabiso Machaba. And the other two, I was led by Unterholter SC and Sibego SC, respectively. And in the Democratic Alliance matter, the other junior was Isabel Goodman. And in the Glenister matter, the other junior was Leah Gabash.
I ask this question deliberately. When you sat in the unopposed motion court, you do confirm, well, maybe I don't know what your experience was. My experience is that the counsel who appear in the unopposed motion court are white, predominantly.
Predominantly, yes.
And those who appear in the civil trial roll call, the settlement court, predominantly black.
That is so.
That gives us a bad name, don't you think? That blacks are only good to settle matters.
JP, it does, and especially that black counsel appear to settle matters in the road accident fund matters. That becomes their daily bread and butter.
Yeah.
There seems to be an absence in matters that would call substantial matters, such as commercial matters,
Yes.
or even opposed motions.
Coming back to the teams you led, when I spent 5 years in the SCA, it was very rare to see black-led legal teams. I don't know what the experience is in the Concord, but I suspect it's the same scenario. And it's a problem to us JPs to understand why is that trend there. So maybe you can share with us in assisting us identifying this, because as JPs, we want to ensure that we invite people who have the confidence to come and do the work of judges.
JP, as far as I can see, it's a question of two answers.
Yeah.
That historically, the persons who have had the benefit of good education, such as studying the fields of law, have been white people because of the privileges that they have always enjoyed. So white people always have the requisite numbers to appear in those courts and appear to dominate those courts. And blacks start at a low base because the doors of learning and culture, so to speak, opened properly post-1994, and we are building that base for excellence in the law. And post 1994, JP, as you know, we had a limited number of senior counsel who could be immediately deployed, so to speak, in matters of substance. So there were rare occasions. If I remember, Tembegile Square was one of the few commercial law practitioners as counsel. And then there were many others who excelled in the field of human rights, which was almost forced upon us to go into the field of human rights, considering the struggle against apartheid. And post 1994, the reason is really that although the law schools have produced what I consider to be an excellent crop of black and women advocates, they have not been able to be afforded the same opportunities that are afforded white members of the bar.
Thank you very much for that. You see, I ask the question deliberately as JP because, as I said, you and Advocate Madima are the first black silks to become available for an interview for a High Court appointment in a long time. Since I've taken over as JP from the Labour Court days till now, it's over 6 years. What is it that we can do as JPs to attract more? Because if you look at the complexion of the bench, you have more people from the attorneys' ranks who are black, who are in the judiciary. I'm from there. A number of my judges are from there. And then you have an oversupply of white silks. How do we balance it?
JP, there is that difficulty
Yes.
that the judiciary can only make recommendations. The judiciary can make observations about the death of black and women counsel in your courts. The judiciary can also make strong recommendations within the limited interactions that the judiciary has with the executive, to point out that the continuing pattern that we all complain about does not say much for the transformation that the Constitution promises, and that government across the board promises is their agenda for the advancement of South Africa.
Yeah. One last question from me. The experience you've gained as an advocate and as a senior counsel, coupled with the acting appointments, the acting stints you've had, you feel those eminently qualify you to become permanent?
They do, Judge President. After 21 years of practice, I have not had any adverse comment from my colleagues about my advocacy skills, about my conduct in court, my collegiality. I have not had adverse comments from members of the bar who have appeared before me as an acting judge. I have not have any adverse comments from judges, both in Pretoria and Johannesburg, that I've interacted with during my acting stints. On occasion, when a judgment that I think needs particular attention because of its importance, I have sought the views of a fellow judge or fellow judges, and on each occasion I've been found to have been on the right track, and my judgments have been praised with obviously a comment here or there about how I could improve my judgment.
Thank you, Advocate Malindi. Thank you, CJ.
Thank you, JP. MEC?
Thank you so much, Honorable Chair. Let me clear just a small technicality here. I see you share your birthday with the late President Nelson Mandela.
I do.
But I see your ID number does not follow that sequence.
Yes, it is one of those incongruencies of going to Bantu affairs offices where dates and names sometimes get incorrect recorded.
Okay, thanks. No, I wanted to clarify that so that we are dead sure that you are speaking to the right person. I'm one of the few people that were inspired by the Delmas trial. Actually, I attended the Delmas trial. People like yourself, the late Bafumile Vilagazi, Ntate Tom Mantat and the rest, it represented, that court represented a state institution that was biased to a certain policy. Don't you think that your open membership to a certain political party will alienate in the same fashion other political parties and other people who might feel that your judgment will be clouded by your political affiliation? Nothing wrong to belong to a political party, by the way, but I know many people who don't declare their political membership here, but their ex confirm their political membership. But you are brave enough to declare your membership to a political party.
Commissioner Lesufi, I have that strong, or had that strong political affiliation. I do not believe it will affect my functioning as a judicial officer. My ability to act in an objective and impartial manner was demonstrated even within the African National Congress by my participation, as it appears in my forms, of being in the Provincial Disciplinary Committee as a panelist, as a person who, when called upon in terms of the constitution of the ANC to represent any party in a dispute, whether the complainant or otherwise, I did that with honesty and integrity. I have had no complaint from any member of the ANC that I acted impartially and under the influence of any directive from the ANC itself. And as a judicial officer, if appointed, it must be emphasized that one has to take an oath or to affirm the oath that is set out in the Constitution, and I will not deviate from exercising impartiality, acting without fear or favor or prejudice in terms of that oath that I will undertake if appointed.
You have declared a series of business interests, 34 to be precise.
Yes.
But there's one that has caught my eye called Mvelampanda Empowerment Trust. What is it?
Commissioner Lesufi, Mr. Sekhwale has about 3 family trusts. He invited me to assist him to look after his family affairs. And I may add that then the companies, the majority of which you see on page 16 of my application, are companies that fall under those trusts, the 3 trusts. So it's really not individual companies that I am a director of, but they are vehicles that are used by the family trusts. I can tell you the exceptions. Number one is the Val River City Tourism Promotion Company that I was recently appointed to. So it's a company that I take no fees from. The number four is a company that I resigned from many years ago. Number 9, I resigned many years ago. Number 10, I resigned many years ago. 21, similarly. The Common Room is a company that was started by me and members of the bar, hoping that it will be a platform for members of the bar to exchange views now that we no longer have a common room where we have tea together and share our war stories. Digela Family Trust is a family trust of Miki Digela, which Commissioner Lusuf, you might know. Number 34 is an education trust which produces educational material, especially in video, and does it for schools and other companies that wish to provide education for their employees. The rest, for all intents and purposes, are the Sekhuale Family Trust companies. That's it.
TJS Family Trust, it has something to do with Mr. Julius Sillo Family Trust?
No, it's Tokyo Judy
Okay.
Family Trust.
Thank you so much.
Sure.
Thank you. Commissioner Nyambi.
Thank you, CJ. Afternoon.
Commissioner Nyambi.
Let me first comment your impressive CV. The first question is in relation to being a member of Gauteng Champion for Social Cohesion. Maybe if you can share with us your personal contribution and your assessment of what you have done for Gauteng and South Africa in general about that issue of social cohesion and nation building.
Commissioner Nyambi, we have a mandate to develop a program that the Gauteng government can embark on in enhancing social cohesion. The report is due in 2019. We will, in October the 13th, present a full program that we believe that as a group, hand in hand with the Gauteng government, may embark on. So we haven't started work, but we have put together a concept document which the Premier will approve shortly. I believe that it's an organization that works in concert with the National Program on Nation Building and Social Cohesion. And we have had one engagement so far, which was to visit the Pretoria High School for Girls. I was not part of that delegation, but the reports that we got at our last meeting was informative and gave us an indication that it is absolutely necessary to have such a group so that whatever the Gauteng government does, it does not appear as if the ruling party is propagating a certain idea of what nation building or social cohesion involves.
do you believe in judicial activism?
There are two questions to judicial activism. Before we became a constitutional state, we obviously celebrated judicial activism because the South African judiciary was not in keeping with the international norms and conventions that advanced and encouraged states to afford individual liberty and especially socio-economic rights. We now have a constitution which I believe encourages judicial activism, because the constitution says judicial officers must not only interpret the law in terms of our constitution and the laws that bring such provisions into effect, but may seek assistance in other instruments such as international law and customary law, etc. So I believe that when South African law per se does not provide an answer, a judicial officer must look beyond that law and see if there's any other law that is consistent with providing freedom and the liberties that our constitution warrants. I don't have an answer whether if, after considering international law and other instruments, with a case confronting a South African judicial officer, whether they are available to extend their activism beyond that point. So it's something that requires a bit of debate.
Is it correct for politicians to criticize judges?
The Chief Justice recently led a group of leaders of the judiciary, and they met with the executive. I believe that there was a general consensus on the extremes to which politicians may criticize the judiciary, and key to that is that it must not be gratuitous. It must be criticism that is based on the matter that was being considered and that a politician does not believe was well considered by the judge. So politicians may criticize to the extent that they bound themselves to criticize within those bounds that were agreed at that recent meeting.
What about judges criticizing politicians?
Judges are the custodians of the Constitution, to the extent that judges believe that a politician has shown disregard and especially disdain for the Constitution, judges may do so. I would qualify that by also stating that in that very same agreement, there are parameters, there are methods of criticizing politicians, and I take it you mean outside of a judgment or a ruling that a judge has made. And a question of the occasion is very important for both judges and politicians. A sense of occasion is important.
Thank you, CJ.
Thank you very much, Commissioner Nyambi. Commissioner Ntsebeza.
Thank you. Thank you, Chief Justice. Advocate Malindi, I want to ask you about what is in your questionnaire. And it seems to me that in the course of your career as an active member of the African National Congress, you have been a member of the Gauteng Provincial Disciplinary Committee, and particularly between the years 2013 to 2016, you have been what virtually was a prosecutor in the ANC disciplinary structures. Now, what I want to know is whether in the course of your duties in that capacity, you were involved in any shape or form with the prosecution in the disciplinary structures of the ANC of one Julius Sillo Malema. And if you were, one would like to then ask the further question whether, in whatever capacity you did so, seeing that he is now a member of this body, you would be able to give this body an assurance that you would be impartial in the discharge of your duties as is required of a judicial officer if you were to be recommended.
Commissioner Tsebeza, the standard that you are asking me about is a standard that we apply rigorously within ANC processes. I did prosecute Commissioner Malema. At the time, I was not a designated presenter, as we say, or prosecutor. I was requested to represent or assist the national prosecutor. And I discharged my functions as required by the ANC's constitution, that structures of the ANC, when they bring charges against members, can draw from members to discharge those duties. And it could have been the other way around, and I could have been asked to represent the charged member. Our duty is to, as prosecutors, present evidence in an objective manner so that the panel that is to take the final decision has had the benefit of those submissions. And those submissions by a team of prosecutors are always tempered by counter submissions from representatives of charged members. I believe that the oath, when I took membership of the ANC, to be that member that is loyal and disciplined and carries out the functions of the ANC as required, is of importance as the oath that I will take if I do become a judicial officer, to dispense justice to all equally without fear, favor, or prejudice.
Just a follow-up question. Now, to what extent, therefore, is a national initiator, which is what you have here in your CV, otherwise a prosecutor, expected to act as independently as prosecutors in terms of our constitution and the enabling legislation, expected to act as far as independence is concerned? In other words, if I were to be blunt, to what extent does a national initiator or prosecutor in an ANC disciplinary inquiry expected to exercise an independence from, for instance, the Secretary General, the President, or anybody in the so-called top six of the African National Congress? Do they do their biddings, or do they do what they ought to do, namely to present a case as independently as the evidence and the charges in terms of the constitution of the ANC allow them to do so?
Commissioner Nsebeza, in my experience, there were lots of interactions with our so-called principals, the top six, to advise them about the strengths and weaknesses of their cases. We made recommendations about which charges we believed could be successfully prosecuted and which ones not. We made recommendations about appropriate sanctions in respects where members were found guilty of those charges that we recommended. Each time that we were approached by our opponents, so to speak, about how things could be dealt with differently, we always went to our principals and insisted that we have a duty to inform them of any offer that comes from the other side, and to hear their views, to advise them whether it was reasonable or not. Certainly in the team that I led, we adhered to that principle. And if I might add, a year or two, someone who's in the leadership of the province commended me for how I ensured from the start, when we developed their disciplinary structures, and then from there being a presiding officer, about how I did not just accept their say-so. They believed that if the leadership says so and so is guilty, that would be it. The other side had to prove their innocence. And I always insisted that that's not how it works. People had to be dragged out of meetings that they considered very important to come and testify, because otherwise we would not proceed with a matter unless proper evidence is placed before us.
Thank you, Chief Justice.
Thank you, Commissioner Nsebeza. Commissioner Schmidt.
Thank you, Chief Justice. Advocate Malindi, you will agree that not only should those who are appointed as a judge be impartial, but also be seen or perceived to be impartial, that there be the necessary trust in that individual by the public to be seen to be impartial. Do you agree?
I agree.
Now, there's basically 9 issues which I'd like to put to you for your comment, which may have a negative impact on that perception of impartiality. And I don't think there's any dispute about the factual basis. It's the interpretation that's my concern, the perception. And they're basically based on what Commissioner Nsibeza has raised, being a PDC member for approximately 13 years, 96 to 2009. Secondly, being a national initiator for the ANC for 3-4 years. You've appeared for the ANC at least 4 times I could find in the Democratic Alliance versus the ANC. Now I represent the DA here, so if there's criticism, it comes from that perception. Fourthly, you're appointed as the ANC Premier's one of 20, let me just get it correctly, prominent champions of social cohesion. It's basically flows from a appointment made by the Premier. Is that correct?
That's so.
You've been a branch chairperson since 1980, or a branch member rather, since 1980, and you've been a branch chairperson since, as I understand correctly, roughly 1997 to 2016. You've been a member, or you are a member of the Kwale Family Trust, who's been the Premier of Gauteng, who's been a minister in the national government. You've been, and not that I keep the fact of your imprisonment against you, because I think that's your right to have acted as you did, but you did so on behalf of, once again, the ANC. I'm not saying, not keeping the incarceration against you, I'm saying, giving you my perception, on behalf of that political party, the ANC. You're part of the Vaal River City Tourism Protection, and I unfortunately come from the Vaal area, represent the Vaal area. And I know that's a political project in Van der Bijl Park to establish a whole Vaal River establishment there. And the Premier has put his name to it. He's come to the Vaal saying, we are driving as ANC government this project. You're once again appointed rather to that company. My concern from these is, how do you try and convince Joe Public, a member of the public, to say this is I can verify for him being an impartial, independent member of the judiciary. And that's my concern, because, and I say so with due respect, I want you to know where I come from. I've never seen a questionnaire and documentation so full of the ANC word or name included in any document. So it is sprawls, by lack of a better word, it may sound negative, but it sprawls with ANC involvement, motivation, commitment, lifelong passion, and whatever, all the adjectives come with it. So my concern is the perception, the very, very strong perception, I wouldn't say real, possibly a real perception, that you would further the cause of the ANC in cases where you would be possibly in a position to do so. What's your reply to those concerns? Thank you.
Just point of order, Chair, if you don't mind. I've been a member of this committee for quite some time as well. So to singly say is the first time you see something with a political nomination here, it's incorrect. We had people that were members of the Boerebrand that came here, and they were interviewed on the membership of the Boerebrand. I just want to rectify that part only. Thanks, Chair.
Thank you, Madam Chair, or Acting Chair. It was more about the number of occasions on which the ANC is recorded in the application form and the supporting documentation. And I didn't even venture to say that it was a politically nominated process, and it seems to be what the suggestion is from the MEC. That wasn't even part of my objection, but so be it, Madam Chair.
Are you satisfied with that explanation, MEC?
I'll just note it here. Thanks.
All right.
Deputy President, Commissioner Smith, starting with the Gauteng Champions for Nation Building and Social Cohesion, the Premier deliberately chose to appoint a diverse group of people. They are not only ANC members or serving ANC members. The name that comes to fore, who's a very valued member of the group, is Rene Tariart. And there are others who come from the union movement, a representative of Nehau. You might say Nehau is an ally of the ANC through COSATU. But there are others who are not as close to the ANC in terms of activism, like Brigelia Bam, who's a former chairperson of the IEC, etc. So if I had the list before me, I could quote a few others that were not chosen because an ANC grouping was being chosen. Coming to the Vaal River City, I come from that area. I've seen the devastation that the Vaal was when I still lived there, and further deterioration in the last 30 years that I've left the area. I see it not as a deployment by the mayor of Tshwane, but as a way of seeking people that could assist the city to address the question of economic revival in the area, especially through tourism, etc. Again, he has tried to draw people who have a history and some qualifications to assist him, such as Silas Zemu, who was in one of the City of Joburg companies, is an engineer, is a highly qualified person. We believe it's a group that on a non-partisan manner can assist to revive the economic woes of the Vaal Triangle. And the ANC generally, there are many members of society that have transcended their political membership in order to act in the interest of the country, whether they were Chief Justice Langa, who was a member of the ANC and Nadel president until the day he was nominated to the bench, and is a celebrated CJ. Dikgang Moseneke, who originally was a member of the PAC, and is a celebrated former DCJ. I believe that when society has agreed, as we have agreed through the pact we reached through our constitution in 1996, calls upon people to play a positive role to rebuild the country, I will always call to that call, and I do not expect people that I'm politically aligned to demand that I do their political bidding, if there is any.
Don't you think it would be wise to have some form of separation in time by virtue of these positions and roles you fulfilled and your possible nomination to become a High Court judge? In other words, that, and understanding that you're still a member of the national initiators, still a member, chairperson of the branch. And why I say so is you were acting as a judge whilst maintaining this position. Not that I say you're not allowed to, because clearly I think it's indicated that you may, but it shows the level of lack of separation, rather, between you and the ANC. And that creates an uneasiness, at least, to put it that way, between your possible appointment and your lack of distance from the ANC. Would you like to comment on that?
Well, as a matter of fact, my membership of the African National Congress lapsed in February this year, and I received notification to renew, and I did not, because I was already considering whether the time has not come for me to serve my country differently, which is what I'm requesting that you recommend me to do from now on. So I'm not a chairperson. I was appointed as initiator after the Mangaung conference, December 2014, the following year, when the NEC met, but my membership has lapsed. I have not prosecuted any member since then. However, to the extent that perceptions exist, the law requires that if there is a perception, indeed it must be established that it's a reasonable perception. So if I appear in a court and a person has a reasonable perception, they must apply for my recusal, and if it is established that they have a reasonable perception, I will have no hesitation to recuse myself. I think that's the Sarfu versus Mandela case, where it sets out the grounds for requiring someone to recuse themselves. So basically, as we say in law, it's not a request for the taking just because you feel you have an antipathy to a person. They must recuse themselves. And I'm applying in a division of some more than 30 members. So the judge president or deputy judge president, if they feel, knowing my background, that being allocated a member may raise that concern, they are at liberty not to even give it to me. There'll be so many other people who give it to. And then secondly, the work of a judicial officer is very diverse. I think in a term where I have to sit in 4 different roles, it's unlikely that situation will arise. It is rare that I'll be in an opposed matter or a trial where there may be an objection. My day-to-day life will be in matters where it does not matter who does it. But of course, as I have said, I believe that I have the ability to disabuse myself of any political or ideological leaning, because I have a different duty to discharge, and that is discharging a duty as a judicial officer.
Commissioner Singh, colleagues, just to give you a sense of where we are, 55 minutes. Very well. Commissioner Singh.
Thank you, CJ, and good afternoon, Advocate Malindi. I think your last response to the question by Commissioner Schmidt was more helpful in that you gave us a time frame of when you had resigned. And I think if that was indicated when the MEC had asked that question, because you went on to give what you do in the ANC and what you don't do, you just fell short of saying that you had resigned in February, because that would have helped me. And I'm not going to ask further questions on that matter. But my other question relates to, I just want to know, Advocate Malindi, would you agree that if there's any matter that you feel that would cause you embarrassment if you are appointed as a judge, the same kind of embarrassment would be felt by the body that would appoint you, which is the JSC? And I'm saying this.
I beg your pardon, I don't understand the question.
You don't understand. I'm saying this because in section 4, you've indicated there that there is a matter in response to a specific question that could cause you embarrassment in undertaking the office of a judge. And you go on to list the matter and give us details of that matter. Now, how do you think that would impact on the JSC should we appoint you would it not cause embarrassment to the JSC as well? Because this seems to be quite a serious matter. And how would you deal with it if you are appointed?
Commissioner Singh, I agree. I disclosed that matter, and obviously in the unlikelihood that I'm quoted as a witness and as an adverse finding, it will embarrass me. It will cause embarrassment to the JSC, and at that time the JSC may decide whether it's a matter to be dealt with in terms of the conduct committee or not. But I can tell you, if the finding is that I was dishonest, and the finding of dishonesty in this profession is a serious finding, I would readily resign without the judicial committee having to consider it. It's unlikely to get to that, and if I may add a little bit, in the dispute, the trusts are being sought to be joined, to be part of the joint estate. And from the advice that I've got and my knowledge of how these things work, it's a legal question. So if the trusts are made part of the joint estate, then there's an order of division of the joint estate. I might not even be required to give evidence, and I think that's how far I can take it.
Thank you, TJ. All I can say is I respect you for having disclosed this particular issue here in the questionnaire that was put to you. And I think it's up to the JSC to consider it further in deliberations. Thank you.
Thank you, Commissioner Singh. Commissioner Malema.
Thank you very much, CJ. Have you written any public articles on any matter of national importance?
I have.
Like which one?
I have written articles on behalf of the National Association of Democratic Lawyers, and I've written articles in support of the conference called by the Chief Justice in protest against the attacks on the judiciary. I have written articles on whether the duties of the public protector are binding. I have written articles on matters of the conflict in Palestine and Israel. I've written as publicity secretary of the UDF many articles commenting on national issues, and even those that I did not personally write were issued by the organization that I serve.
So, you didn't see a need to write an article when the judges were called reactionary?
I believe we did to protest against judges being called revolutionaries.
No, I'm talking about you. You didn't write any article in defense of judges being called reactionary.
Personally, I don't remember writing as an individual, no.
Was there no need from you to write an individual to write an article in defense of the judiciary, since it was attacked by, amongst others, the people who happen to work with you politically, to try and clarify the independence of the judiciary, as it were?
I believe that my views against the judiciary being called counter-revolutionaries and other aspersions being passed against it will carry more weight if issued collectively by an organization such as NADEL, which I believe has an admirable standing in the legal field.
But you just said you wrote articles. Even when organizations pronounce themselves, you still wrote articles as an individual to express yourself.
I meant as publicity secretary of NADEL. I'm sorry, you misunderstood me.
You never wrote an article in your life
Capacity.
as an individual to write. That's the first question I asked. If you never wrote an article in your individual capacity to contribute to a national discourse.
I believe I did. I tried to find, search for such articles, which I have not come across, but I have on a number of occasions written to newspapers as an individual.
What impression will it create for a DG of finance to resign from finance and immediately become a CEO of a bank? You think it's advisable?
I don't think it's advisable, and it's something that has received a lot of commentary about people who occupy positions in organs of state, and then when their terms expire, or sometimes even before, they find employment in agencies that are private corporations especially.
And as a result, in that too much commentary, there's been a call for a cooling off period before they assume such responsibilities.
That is true, and it's commendable.
And given your history, which you outlined on your own, don't you think there must be a cooling off period between your political involvement, too active political involvement, into becoming a judge?
I think the decisive criteria is one that is set in the Constitution. If I am suitably qualified, and if I will satisfy the need to accommodate the dearth of representativity on the bench, it is important. It is also important if I have succeeded to convincing members of the commission that indeed I will make that transition without requiring that transition period. I should be appointable, and the judge president has taken the committee through my involvement as an acting judge, as I was very active in the ANC, and there has not been a complaint that my membership of the ANC, even at the time, clouded my judgment in many respects, in any respect.
My brother, we just agreed that there's too much commentary on people who leave their certain strategic positions to assume certain positions, and as a result, we further agree that there must be a cooling off periods to deal with a possible perception of conflict of interest. And then when it comes to you, that principle completely changes. All those people, the DG of finance who leaves finance to become CEO of a bank, constitutionally and in terms of everything else that you said, they are qualified. There's no constitutional disqualification of those people. They are qualified. But we agreed that through this too many commentary, there must be a cooling of periods to avoid the misperception. Is that not a necessary thing to do?
Indeed, we agree in that respect, and if the qualification I will add is that commercial interest is very important because the perception is that people place them in government positions where they can easily use that position to gain better financial benefit. I am living practice, and it is recorded that people at my age are at their peak, and I am choosing to serve society instead of pursuing a lucrative practice.
Now, there are a lot of benefits which you can't get when you are a practitioner, but we'll not talk about that. Can you imagine what the headline is going to be? And you must tell me if this helps to enhance the good image of the judiciary. The JSC appoints the ANC national prosecutor as a high court judge. Does that help us?
If discerning readers consider this interview that I have gone through, I believe that they will realize that the JSC has appointed someone who indeed is capable of living through the oath of office as loyally as he has served in other structures loyally.
My brother, I'm not questioning your qualification and your loyalty. You are extremely too involved with politics and with politicians, whereas you are involved in Tokyo Sehwale's businesses, not just a businessman. Tokyo is a politician. Your hands are there. You are in the national prosecution team of the ANC. You are in the provincial disciplinary committee of the ANC. All of that, you are now going to be a judge immediately after leaving those things. It doesn't help, and I'll put it to you, it doesn't help to enhance the good image of the JSC, especially in the context where a country is seized with debates like state capture and cadreship deployment. Does it help us? Because I think the good thing will have been, and which you tried in February, but it's too short period. The good thing would have been to take a break from all of these things, so that after some time you return and then be asked to be a judge. But immediately from these positions into becoming a judge, it's going to be seen and is going to feed into a narrative that the judiciary is captured, that the ANC has deployed, and the factional battles of the ANC will say, Tokyo Sehwale has actually deployed a judge. Would I be unfair to have that perception?
Well, in closing on this question, Chief Justice, I can only say that I have laid bare before the JSC who I am and why I am here. And it's for the JSC to judge. And in the discourse, and it has happened in this forum, that there is no judge, consciously or unconsciously, who's untouched by their ideological upbringing. Some who still adhere to those political upbringings. All judicial officers are constrained by the need to perform their functions without the constraints of the Constitution. That is what I will do.
CJ, I don't know in closing, what does it mean? Does it mean I must not ask this question anymore? What does it mean? In closing, it means I must not ask this question. He can't tell me that.
You are free to put...
That's arrogance. He can't tell me that.
Commissioner, you are free to put questions.
Now, my question is, and whether you like it or not, I'm going to ask it. The question is, your appointment immediately from the chair of the ANC into the bench, does it help to enhance the image of the judiciary? That's a question I'm asking.
My answer, Commissioner Malema, is that the message that will be sent out there will be that a person who has, through their lives, from at least the age of 16, fought for freedom and was an adherent of the Freedom Charter, is a champion of the Constitution, has been appointed, and from what he has told the Commission, it only confirms that he is still of the view that human rights, dignity, freedom, and all the other precepts that are enshrined in our Constitution are still paramount to him, and he undertakes to champion those rights as much as he championed the struggle.
Now, let me leave it because I don't want to be seen to be pursuing something else. There was a question about members of the ANC, and you said JP and the DJP, if they think these are members, they will then not give you that task. It means you're not going to do anything. Because the ANC is a majority party. And majority of, we assume, many of those people who come before the courts, the majority are members of the ANC. If that cannot be verified, we always litigate against ministers, DGs, councillors, premiers, MECs. It means you're not going to hear any case. Because these members of the ANC, every time they have come before you, JP, you heard the message, you must transfer the message to DJP. You're going to hire a judge who can listen to these people because they are members. How are we going to deal with that? How is it practically going to be done?
Point of order, Chair, if you don't mind.
No,
and he did that earlier on. We just kept quiet. And if you are going to allow this precedence, it's going to be a problem.
Let me see. It's unlike in Parliament. Yes.
Chief Justice, I understood the question to be directed to you.
A question by?
By Commissioner Malema.
Oh, I was distracted by the point of order. So, Commissioner, I didn't hear your
I never asked you a question, CJ. I asked him.
Okay,
I thought so, but I thought while I was talking to the MEC, some other question arose that was directed at me.
Chief Justice, as I said earlier, when I sit in the unopposed divorce case, unless a name stands out, I don't know that they are ANC people. If I sit in a criminal matter, unless the relevance of political affiliation comes to the fore, maybe people stabbed each other at an ANC conference or in confrontation with other political parties, it will come to my attention. In almost every role that I sit on, membership of political parties does not appear apparent from the role. It will not arise. If on those rare occasions it arises, I will conduct myself like any judicial officers who often will have the parties in chambers and say, so-and-so is the leader of my group. Do you have an objection to me hearing the matter? People express their views. Usually people don't have those objections. If someone is a prominent member of the ANC and everyone can see, and I know the person personally, let's say Mr. Swale appears before me, and I'll say to the representative, I've had this relationship with Mr. Swale. Obviously, I will resign from the trust if appointed. I had this relationship with Mr. Skhwale. Do you have any objection to me sitting in it? In some instances, I will be told outright that an application for recusal will be made. The DJP and the DJP will make a call, and that will apply in any cases where there is a perception of bias, and I say, if appointed, I will take the oath which is in our constitution and discharge my judicial functions in terms of that oath, and my appointment will not send the wrong message out there.
The last point I want to ask, will I be unfair to ask you to withdraw your candidature, given the fact that we have now canvassed your close proximity to political activities and the fact that you are still holding some political responsibility in the ruling party? To withdraw your candidature and allow a cooling off period, which we spoke about and agreed that is a necessary thing to do, and then return after some cooling off period. Will I be unfair to ask of you to do that?
It will be unfair, Commissioner Malema. After what I have stated here, I don't believe that this is a circumstance that requires that cooling off period. And of course, I'm in the hands of the judicial officer. If I'm not appointed, I will take a few years to distance myself from the ANC. I have other interests at the bar, but I'm not withdrawing my candidature.
Your brief comment on the state capture. What is a state capture? What is your understanding of a state capture? Does it include a potential judicial capture?
It does. We know that in many jurisdictions, especially ones that do not have a process such as the JSC, presidents have a freer hand to appoint judges of the higher courts. And we know that in particular in America, there is a fight about conservative judges or liberal judges will be appointed. There is a safety guard in this process in South Africa that consists of all these representatives. It is your duty to convince the others that if I'm appointed, it will be analogous to appointing someone who's still too close to a political party, and that such appointment will be analogous to state capture, and I will be interested in the evidence that is placed to suggest that I am a political deployee, quote unquote. And in South Africa, the Judicial Services Commission was established to ensure that the appointments are dominated not by any one sector of the legal field. It's represented by politicians that range from the ruling party to minority parties. It is established of legal practitioners from all recognized regulatory bodies of the law. It is constituted by heads of the various courts, and I trust their judgment on this matter to determine whether I am a political deployee or a genuine person who has gone through 21 years of service in the profession and who has displayed what the criteria for the JSC requires of them.
Minister.
No, thank you, Chief Justice. And afternoon, Advocate Malindi. The perception of abuse of court process through what is commonly known as not capture this time around, but forum shopping has been spoken widely about. Would you like to comment based on your own experience working in the courts?
Good afternoon, Minister. Minister, the issue that you raise has been with us certainly in my time since 1998, when the Arbitration Foundation for Southern Africa was established. There was a strong view at the time that it was established to avoid the bringing of, in particular, commercial cases to the high courts, which were being staffed by black and women practitioners in order to transform the bench. Obviously, the people who championed the establishment of arbitration forums protested and said they were doing it so because the world, especially in commercial arbitration, sought to arbitrate their disputes in a more speedy way than the courts. But it was clouded by questions of racism. I have no direct evidence, but I still hear that there are many practitioners who arrive, realize which judge they've been allocated to, and immediately ask for a 1 hour adjournment, and then the next moment they arrive to say the parties have agreed to go to arbitration. It is still a problem, and but it is less so in my experience.
Is it true that it's also used to manipulate the system in a manner that would avoid or conversely prefer particular judges because of perceived inclinations, personal inclinations of those judges in the manner in which they approach matters before them?
Chief Justice, again, I'm not a full-time judge, but I have heard, again, without providing you with evidence, that in particular, because practitioners now have the advantage of knowing which judges are sitting on which role, to enroll their matters in a particular week when they believe a judge that will be more amenable to their cause would hear them, and they practitioners have a way of manipulating that. And so these are perceptions that require to be ventilated openly with all the practitioners, legal bodies, because the perception persists.
Yes. And just stepping off the judiciary specifically, and this kind of perceptions, there is another difficulty of opportunistic litigation or perceived opportunistic litigation, specifically against the state, with the consequence in quotes of seeking to fleece the state unduly, especially in particular areas of practice. We've observed third-party and medical malpractice claims where some practitioners have even been struck off because of certain abuses. do you believe that the judiciary has a role to play in being on the lookout of such malpractices when they observe them in their courts? Or is it something that they should turn a blind eye to and leave it to whoever is responsible to do so?
Minister, in my last acting stint, that matter was a subject of a workshop where there was debate about to what extent judges may interfere, in particular in those matters that practitioners have been struck off. They are mainly RAF matters, and there were other matters of a lesser scale that were involved. Next to RAF matters are matters of unlawful arrest and detention, where sometimes in one weekend, one police station would produce up to 20 cases of unlawful arrest and detention by one attorney and similar claims, and most of them end up by not being defended and they seek default judgments. And judges seek to appeal, to interfere by themselves calling upon the state attorney to appear, usually to find out they are not even aware of the set downs. But the problem does not only lie with opportunistic practitioners who seek to fleece the state in RAF and unlawful detention and arrest and detention matters, but it also lies with the inefficiencies in the office of the state attorney and the inefficiencies of the station commanders from whose stations these cases mainly emanate. So there is a greater role to be played by the state than the judiciary. I believe that the judiciary has a specific role assigned to them by the Constitution, but being part of the justice system, they are always mindful of the fact that they are dealing with state money and that they cannot give orders if and when they are asked for, even when they see that there may be potential abuse in the process.
Thank you very much, Chief Justice.
Thank you, Minister. Commissioner Nogesi.
Thank you very much, Chief Justice. Advocate Malindi, is just a few things to clarify from you. One, you have been an acting judge and you have just been acting in the labor court. Has there any paper been written that an ANC person has been appointed as a judge? Has been such a paper?
There has not been, and usually there is no practice to scrutinize us so closely when we are appointed as acting judges.
Secondly, your understanding of the independence of the judiciary. Just what can you say? Like, if you are appointed as a judge, what is expected of you as a judge?
Commissioner Nojesi, most judges, and I in particular, place more stead to the fact that being a judge is a bestowal of one of the most important services that a person may afford to society, and it's not a bestowal that must be taken seriously. You are being bestowed as one of the arms of government.
You mean it must be taken seriously?
It must be taken seriously.
It was a slip then, okay.
Yeah.
It must be taken seriously, And this process is to ensure that anyone who makes themselves available is someone who will take it as seriously as the Constitution demands.
Thank you. I'm asking you this question, perhaps, just to ensure that I understand you. We have been asked a lot of questions about your ANC membership. When there is an oath of office that judges take when they are appointed. So I just wanted you to reflect towards that. That is the reason. Otherwise, I'm sorry. Lastly, Mr. Malindi, what is your position with relation to judicial accountability?
Judicial accountability is has been made more stringent in South Africa. My deputy judge president, my JP, if appointed, are there to ensure that I account to them. I discharge the work as the leaders that I work under. The Judicial Service Commission has now established a judicial conduct committee, and my judicial accountability is even under more scrutiny. And as a judge, if appointed, society now has more liberty to scrutinize my conduct as judicial officer. My judgments must demonstrate to everyone that I am worth the person that has been appointed, and should I fail in that regard, there are mechanisms to make me accountable and to remove me as a judge if possible. And personally, if there is any reasonable or objective reason by any of these stakeholders to come to the conclusion that I'm failing in that regard, I will remove myself without seeking JSC processes.
Thank you very much, Chief Justice. Thank you very much, Mr. Malindi. I know you as a president of NADEL, and I know you have acquitted yourself well whenever you are given a task.
Commissioner Stock.
No, thank you, CJ. Good afternoon, Advocate Malindi.
Good afternoon.
Just two brief questions. The first one, in your CV, you have indicated that you were a member of the Gauteng Provincial Disciplinary Committee. Is that correct?
That is correct, yes.
And then you also indicated that you were also appointed by the ANC NEC as a national prosecutor, as an initiator.
That is so.
Okay, so I want you just to give us a benefit of the doubt so that we understand that these two positions, because the other one is in the province, the other one is at the national level, were these concurrent functions, in a sense that were you doing all these responsibilities at the same time? You were at the province, you were at national, or you first resigned in the province and then you were appointed at national?
No, I first resigned from the province, then I was appointed to the National Committee of Initiators.
The other issue I wanted to find out also from you, as a national prosecutor of the ANC, what were the nature of the cases that you dealt with mainly, in the main? But I'm actually not looking for a long elaboration of the different cases. if you can just give us a summary of some of the cases, maybe one or two cases that you dealt with. I know there was an issue mentioned about the case of there's somebody that is making noise. I don't know whether that person is intimidating me. Through you, CJ, if you can protect me.
You are protected.
Thank you. I know there was a case mentioned about your involvement when you were initiating against the case where Commissioner Malema was still a member of the ANC at that time. So I'm not speaking about that specific case. I want you just to give us an indication of maybe one or two other cases that you dealt with at that level as a national prosecutor of the ANC.
As a prosecutor of the national prosecuting team, the only case that I've prosecuted to the end is the one of Commissioner Malema. I was supposed to be involved in the case prosecuting Mr. Fransman from the Western Cape. I could not get involved in that matter, and I was not involved in that matter. Immediately after 2011, there were a number of appeal matters that I was supposed to participate in their prosecution. Again, I did not get involved in them. So, for all intents and purposes, after the end of Mr. Malema's prosecution in 2012, I've not been able to prosecute any other.
Will I be correct to assume that you only dealt with one case from the time you were appointed in 2012 up to 2016? Or let me say this year.
That is correct.
Okay. My other question is that I don't want to speak about the other two principles. My colleague, Honorable Nocheshi, has covered the other aspects of the principle of judicial accountability and independence. So I want to focus on the principle of judicial impartiality. What is your understanding about judicial impartiality?
Well, I don't understand anything more than that stands in the oath. I think that's the most succinct statement, that one must discharge justice to all equally, and one must act without fear, favor, or prejudice. And I believe that I have demonstrated that in many cases. I mean, when I started in practice, my main focus was in labor law, and I've represented both unions, employees, and employers, and I have not been criticized for not having acted impartially because of my political affiliation.
The principle of judicial impartiality also speaks about in order for a judge to disperse the rulings in different cases, the judge needs to look at the facts before the judge, and then also the law that applies to that specific case. Do you know anything about that?
I know that to adjudicate a dispute requires that all the facts be placed before one, and judicial officers do their best to bring about a just ruling or judgment on the matter without being partial in favor of one or another party.
My last question to you, Advocate Malindi, will be that if, for an example, the Judicial Service Commission will come to a conclusion to recommend you to be appointed as a judge to the President of the Republic, do you think that it will be a good thing for the judicial services to do?
I believe that it will be a good thing to do, not only for my purpose. I believe that I have come to the stage where I wish to serve society differently. I've tried to serve society throughout my life through the pro bono work, amount of work I do as an individual. the pro bono work that I've insisted that the group I lead does on an individual basis, and we've got 2 of our members who have won in successive years the award for best pro bono practitioners in Johannesburg, and the JSC would, if I understand your question very well, and I hope they agree with me, they will be recommending someone who believes in those principles of the Constitution being the supreme law, rather than what their ideological or political persuasions are, which they must tame to a very large extent when coming to judgment, and make sure that they are fair and impartial.
Thank you, CJ.
Thank you, Commissioner Stock. Commissioner Didiza.
Thank you very much. It's just one question. If one reflects on the discussions that you, or rather the conversation between yourself and Honorable Malima, trying to look at whether or not your political affiliation, even though you might have resigned in February, would, or rather may not affect the perceptions of people about your ability to, to be the impartial judge, if I were to put it in inverted commas. I'm not asking about that, but I'm saying in that discussion, an issue about cooling off period emerged. Would you say, given the political background of our country and how many of its citizens in one way or the other might have been engaged in political activism of all sorts, either in support of the state then or against, would in some way be reflected even in the structure such as the judiciary? Would you then say, if that's the case, maybe the JSC should reflect whether or not there shouldn't be any cooling off period? And if so, how long, in order to make sure that such perceptions do not prevail? Because some other members may not necessarily declare upfront their involvement in any political structure, but they might have been either passive or overt in one way or the other. Thank you, Chair.
Commissioner Titiza, that's the most difficult aspect in any social institution, that there's an assumption that if people do not have an overt political belief, they don't have one. That if people have not acted in favor of any particular organization, they don't have one until you delve. So the question of cooling off period remains necessary, especially if someone is clearly coming directly from a political background. They must demonstrate that it will not affect their work in an institution that requires impartiality and looking at things not through a political prism or not. But it must be a case-by-case basis, because in many cases, as you say, those political biases are not detected. People concede them, although we know them when we speak to them at tea time and at lunch time, that they carry heavy political leanings. Some don't know that they do, but there's no South African citizen whose outlook to life has not been shaped by their political lives in the last many decades of the existence of society. Even people who say, I'm not interested in politics, that view that they are not interested in politics is a reflection of how they view society. So I will not say a political distance between that kind of involvement and a position like a judiciary should be abolished, but I say it's a case-by-case basis. Some people, their past demonstrates more who they'll continue to be. Other people, it demonstrates that they are acting constantly with their beliefs, and sometimes there are other imperatives that must be brought to bear in order to ensure that that institution is as neutral as possible or is reflective of as many views as possible, so that not one view dominate those views. And as for this body, we know it's a body that chooses judicial officers, and the criteria is clear as to the suitability of qualification. They need to satisfy certain requirements of a developmental state, and in this case, representativity on race and gender is crucial. And the added advantage in my case is that I have acted for some 19 weeks in the High Court, some 8 to 12 weeks in the Labour Court, and in my view, no judgment has been pulled out to indicate that I displayed a bias one way or the other in those cases. I believe that I will live by the oath of the office if appointed.
We've interviewed you for almost 2 hours, but I must ask this question. Preamble. And I really don't mean to be insensitive. And to demonstrate that, let me start by saying, when I was interviewed by the JSC the last time, I shed a tear because they asked something about my mother, and it reminded me of what she went through to raise me. So I don't mean to be insensitive. You've shed a tear here, and I stand to be corrected, but I think you did before in a court atmosphere. Is it an area of challenge that might just happen again while you're presiding as a judge if appointed? Or is it something that happens once in a long time, very exceptional circumstances, unlikely to happen while you're presiding as a judge?
Chief Justice, it's unlikely to happen again. It happens once in a while. And if I'm a judicial officer, I'll be more in control of the situation. And if I feel it coming, which I doubt if it will, I will adjourn the court. And I will be doing what judicial officers do almost on a day-to-day basis. When a witness becomes emotional, they are given a time to go and recollect themselves, and court resumes after that. And so it's not an issue that if I'm appointed a judicial officer, it will play itself again in court, because I will know when it's coming, adjourn for 2 minutes or 5 minutes, come back having recollected myself and proceed. And there are few things that get me to that, and it won't happen. And if it does happen, it will be manageable in the sense that I'm suggesting.
By in control, you can say court adjourns, and then you go and do it outside.
Bowl my eyes out in my chambers and come back.
Okay. Thank you very much. Your excuse, Advocate Malindi.
Thank you, Chief Justice.